A new ruling from the Colorado Supreme Court says ski resorts can no longer use waivers to protect themselves from most lawsuits. The lawsuit centers around a 16-year-old who was paralyzed after falling from a ski lift at Crested Butte more than 2 years ago. Annie Miller's family sued, saying the ski area did not do enough to protect her. They say the operator never stopped the lift as Annie hung on before falling. Joining me this morning with the breakdown of this lawsuit is our 9 News legal expert, Whitney Traylor. Thanks for coming in.
Sure, good to be here.
This is pretty fascinating. So how did this end up at the Supreme Court?
Right, so this is really interesting. As you said in the lead-in, the young girl, she was 16 at the time in 2022, and her father were skiing. She wasn't quite on the lift, and so they kept going, and everybody was screaming, stop the lift. And they didn't. There was no operator there. There was no ski lift operator. So she fell at 30 feet and landed on a hard pack, and now she's quadriplegic. And so the issue was at the lower court, so the father and the daughter sued. But when he bought the ticket, he bought it through the Epic Pass. And the Epic Pass, when you go to buy it, you have to click all those things that say, I assume liability. Yes, it's a risky sport. I'm acknowledging that. And so they relied on it. The ski resort said, hey, you waived any rights you had. And the lower court agreed with it. So here they took it to the Supreme Court, and for the first time in Colorado history, the Supreme Court said, no, this waiver is not applicable, and the case can go forward now.
Obviously, this is a huge deal for Colorado, for resorts, skiers, and boarders. For a long time, resorts have pretty much had immunity from lawsuits like this, right? Like it says on the ticket that's on your person that essentially they're immune from things. So how is this going to affect Colorado skiers and boarders?
Well, it's hopefully it doesn't affect a lot of them because it would only come into play if somebody was injured. But here, what they're saying now is if someone, so in this case, the ski lift operator was not there. So if there's another ski lift, an accident on the ski lift, the resort may ultimately be liable. So really the issue is on negligence per se claims specifically. So now we don't have enough time to get into the specifics, but because we have the legislature passed the Ski Safety Act, if somebody is injured because of something contained in the Ski Safety Act, they can still go forward. So in this case, it was chairlift operation, but other things inherently risky to the sport, like going downhill fast and hitting another skier, that they still may be able to waive liability there.
I would assume that ski resorts are not too happy about this ruling.
That's correct. They are not happy. And a lot of people actually, a number of different entities wrote amicus briefs. So friends of the court, they said, we're not even a party to this, but we want to weigh in and tell the court how we think they should rule. And so now that's going to be the question. They're going to say, well, we're either going to have to shut down, we're going to have to raise prices. So how the ski resorts respond will be interesting.
Don't raise the prices. They're already so expensive.
It's already so expensive.
Oh,
Come
man.
on. Yes.
So what happens next with this case?
Right. So this case, so it doesn't mean that they won. It simply means what happened, the ski resort, it was Telluride, was trying to get the case dismissed. And that's ultimately what happened at the lower court. And the Supreme Court said, no, the case can now go forward. So it's remanded back to the trial court and it'll continue to go forward. But on a macro level, this is how our common law system is developed. The legislature passed the Ski Safety Act. The courts are saying, here's what's legal and not legal. But now you're going to have more cases where with slightly different facts, because in this case, she fell off the ski lift. There was no operator there. What if the operator was there but wasn't really paying attention? So when you have these, the law will evolve as these factual scenarios continue to play out. So it's not cut and dry, like if this happens, this is the result. So that's how the law, some people are like, the law is so gray and it's not black and white in a lot of times, and it's not. But this is how our common law system works.
Well, it's kind of meant to be that way because things are so situational, right? Like it can really change. It's not cut and dry. Like if you're on the mountain, then there is like no risk for the resorts. I mean, there are certain aspects in some cases like this one where things could pop up.
That's exactly right. And I had a mentor years ago that said, for the lawyers, if you have bad law, you argue the facts and try and distinguish the facts. If you have bad facts, you highlight the law and kind of stay focused on the law. So I think you're going to see that more and more. So, you know, for the everyday skier, they're saying, well, what does this mean? I mean, really try and stay out of trouble, but the reality, or try not to hurt yourself.
Yeah.
But the reality is that now the ski slopes may be liable in situations they weren't. And again, this is the first time in Colorado history that this waiver issue has come up and the courts have ruled in favor of the skier.
Well, it's a big deal. We're going to be following the case for sure. Whitney, thanks for coming in.
All right.